Alright, hello everyone. Welcome to another League of Investigations. I hope everyone's doing well. Today we'll be talking about Creative Commons, and I'll explain a bit why am I talking about this. But essentially, as you're looking at the screen right now, it's because it's in relation to the D&D fiasco, controversy, or issues happening with it, So yeah, for anyone that is watching this on my YouTube channel, I will be doing a summary at the end of this, and trying to explain quickly or summarize briefly, quickly, and shorten everything to what we should be getting out of this. Everything, like what is Creative Commons, whether this Creative Commons is for everyone or not, who should be using it, is it useful for anyone, do we need to care about these things, as who should care about it really, hopefully it will be useful knowledge. I think it will be for most people that are in business of creating art, music, any sort of creative work, I would say, and they are considering putting it out to the world to share, to adapt, to maybe even monetize, whatever you want to do with it. This could be something that you might want to check out. So yeah, let me just begin explaining the origins of me. Why I'm talking about this one is D&D did something. All right, D&D, the company Wizard Coast, did a lot of stuff, but to summarize it, they basically wanted to, at the beginning, monopolize, or at least gain more control over their intellectual property, so to speak. If anyone doesn't know what is Wizard of the Coast and Dungeons & Dragons, Dungeons & Dragons is a tabletop role-playing game where, people come together and play a game of make-believe, mostly, based on a set of rules, alright? So the concern here is the set of rules, alright, that Wizard of the Coast, the company, wants to control and monetize them even more. And they wanted to do it in the form of updating a thing called OGL, Open Gaming License, where in the past, a big portion of the Dungeons and Dragons rules were put out for people to use without a concern for copyright infringement. I think because the company has allowed them to use it however they like, as long as they don't infringe on certain intellectual properties of the product, right? Mostly it was in relation to the game mechanics, right? We don't really want to talk about. We aren't here to talk about the legality or the how do you say, legality of copywriting game mechanics. That is something we don't really need to focus on. But suffice to say, the current Wizard of the Coast company, their upper management, wants to remove this, or update it and revoke this original Open Gaming License to turn it into something that if people wanted to use it, they have to pay some sort of royalty, some sort of charges, fees, in order to monetize or commercialize the game mechanics and possibly some other intellectual properties they allow third-party publishers to use. So this was a big hoo-ha, for past month, and at the end, Wizard of the Coast seems to have gave up, forfeited the battle of updating the OGL, and decided to leave it alone. But more than just leaving it alone, they decided to announce that everything that was referred in the OGL and the game mechanics and everything will be considered will be licensed under Creative Commons, one of their licenses. So yeah, supposedly this is a very good thing, which I think it is. But what we are confused, I think most people are, who are not experts or savvy in copyright laws, including myself. I'm just like, I've done my research, but I'm not an actual practicing copyright lawyer. So most of it is through my research of understanding copyright law. So from my understanding, it's apparently I had some misconceptions with what is Creative Commons in the past. All I thought this was something like a licensor or something like that. I originally thought Creative Commons is some organization which provides licensors, copyright holders to register their creative works or something like that with special licenses. But not exactly. It's not exactly what they do. They don't actually do, like, I would say, approach copyright holders anyway. They are mostly like providing assets and tools and such. But I'll explain all that in a bit as we go through the various things that we want to find out what exactly is Creative Commons. All right. So so I open up this post. So this is the one that the Wizard of the Coast, the company behind Dungeons and Dragons, said that they will be putting everything on that is the SRD. The SRD is, how do I say this? Let me just open up this document which they declare all this is going to be under the Creative Commons license. So the SRD is called System Reference Document 5.1. So I don't want to bore you with what that document is, but basically it's all the rules and references and things, human objects, characters, whatever it is, rules and such are mentioned in this SRD 5.1, and they are all going to be considered to be licensed out under the Creative Commons Attribution 4.0 International License (CC-BY-4.0). Right, so that's the thing that they mentioned. All this is going to be under that license. So if you want to use it, you just have to follow the requirements of this license. All right. So that's it. That's pretty much it. But it has wide implications for a lot of people. And just giving you all just a bit of background is that originally only the game mechanics can be used for everyone. They specifically say that anything else that is like considered to be D&D's intellectual property, or they use the word property identities. Well, I have to look back the thing at they don't have it here. They do have it here. Sorry, I'm just gonna open this up. Right, the product identity. Yeah, anything they it includes all the product identity. Let's see. Wait, is this something new? Let me. I don't think this is something I actually noticed. Oh yeah, this is the same thing. Anyhow. Oh wait. Yeah, so yeah, it's in the same page. So everything in here is considered to be part of the license. All right, part of the Creative Commons license. Originally, they told everyone in the original OGL, and everything except for the product identities is free use for everyone. But now it seems that I don't think they cover that. They didn't mention that sort of language in this document. So, and this license is supposed to be irrevocable. So I'm not sure they can backtrack. All right, they can backtrack what they've said. So whatever like is considered D&D's intellectual property mentioned in this document, like say there's a monster called Beholder, and it's very famous to be, and very very famous and infamous in the sense that yes, it is Wizard of the Coast intellectual property, but they are very serious about enforcing the copyrights against anyone who uses it without permission. But with this one, with this new license, supposedly we would have no problems referring to anything called beholders, right? Anyhow, so that's but the background. So now we're actually going to look into what's Creative Commons. So we have the wiki page, which I'll just read through the first paragraph of this thing, right? Creative Commons is an American non-profit organization, an international network devoted to educational access and expanding the range of creative works available for others to build upon legally and to share. Right. So they are a non-profit organization, an international network. Right. The organization has released several copyright licenses known as Creative Commons licenses, free of charge to the public. These licenses allow authors of creative works to communicate which rights they reserve and which rights they waive for the benefit of recipients or other creators. An easy-to-understand one-page explanation of rights with associated visual symbols explains the specifics of each Creative Commons license. Content owners still maintain their copyright, but Creative Commons licenses give standard releases that replace the individual negotiations for specific rights between a copyright owner, licensor, and licensee that are necessary under an all rights reserved copyright management. Right, so from this sentence and as well as this is their page, the Creative Commons website, and again they tell you what they are. Creative Commons is a non-profit organization that helps overcome legal obstacles to sharing of knowledge and creativity to address the world's most pressing challenges. Right. And again, they say provide common Creative Commons licenses and public domain tools that give every person and organization in the world a free, simple, and standardized way to grant copyright permissions for creative and academic works, ensure proper attribution, and allow others to copy, distribute, and make use of their works. Right. So everything else is not really that important. They are a huge organization, at least from looking at this, because they are part of a lot of things. And the second one, it even mentioned that they work closely with major institutions and governments, right, to create and adopt and implement open licensing and ensure the correct use of CC licenses and CC licensed content. Right, so this is a huge organization, which just reading from this paragraphs is that yes, they are providing like which I can tell is terms and conditions. They're providing a template for terms and conditions where supposedly all these templates of license templates would be enforceable in the entire world. That is what I interpret this as, which I think is also is quite correct. Almost the entire, I think even in Malaysia, I've seen this Creative Commons being used in some products, like some creative works. So yeah, and I think it's organizations. Yeah, they are pretty old. They have been founded since 2001, 22 years ago. Right, 22 years ago. It's a long time ago. And yeah, so pretty legit, like, if you ask me. So yeah, we'll be looking one of the licenses where we won't talk, we won't like examine the entire license. We're just going to find out what exactly, how do they present all these licenses, right? How do they present CC licenses to everyone, and how you can use it and all that. That is what we're concerned with. We want to learn about. All right. So since this is in relation to this document, to the D&D controversy, and they mentioned they are using the Creative Commons Attribution 4.0 International License, CC-BY-D 4.0. So we'll only be looking at this specific type of license, all right? And what it is all about. So I already opened up this Creative Commons license page and looked through all the things. So over here, they talk about the different types of licenses, which are quite simple. There's only 6 of them, and I would say quite easy to understand as well if you just go through all 6 of them. It's essentially, they are sorted from the least restrictive to the most restrictive license, right? And of course, there are public domain. You can public domain terms and conditions, something like that, where you can turn any creative works into a public domain, so there's no restrictions at all to use the creative works that you've labeled it as they put it, CC0, right? Which allows creators to give up their copyright and put their works into the worldwide public domain. CC0 allows reusers to distribute, remix, adapt, and build upon their material in any medium or format with no conditions. So this is public domain, but I say in any case, right? In any case, there are all these licenses. I can tell you now, at the very least, without looking at the terms and conditions, right, is that who will be using this? And if you're asking that, I can tell you, not a lot of people will be using this. At least if we're talking about the YouTuber community or the streamers community or art commissioners or people who make a living out of creative works, won't exactly be using any of this stuff because these licenses are open licenses, right? It's not a term you'd normally hear, but essentially open licenses is license with terms and conditions that is put out into the public, right? You basically, if you created something, maybe you created an art piece that is very, very good, or whatever, it's uniquely yours, but you want people to use it in some way, in some form. You want people to make fan art of it or whatever. I would say a better analogy would be, if let's say I use myself as an example. If since Jake Light, the VTuber model, is all mine, is considered mine, my copyright work. But if I want people to freely use it for commercial purposes or personal purposes, anyone, I won't be like that. There's no person that I need to direct to. I just want everyone to be able to use my work for whatever reason, right? Then this is the license that I would be using. This is the license that I will tell people, yeah, I just put this mark, this CC license mark on my work, and tell people, yes, Jake Light is under the, I'm just giving an example, all right? This is not binding or anything. Jake Light, the VTuber model, is under the CC license CC-BY or whatever, and anyone can use it as long as they follow the terms and conditions under the CC license. So that is essentially what this does, right? Allowing people to have a peace of mind to use your work commercially or non-commercially. And it's a pretty how do you say, risky thing to do. It's a dangerous thing to do if you don't exactly know what this is. You don't know the terms and conditions in the license, because a most important thing is Creative Commons license. Since it's an open license, right? It's a license to everyone. You can't revoke it. There is we'll look into it. We'll looking exactly into the terms and conditions. But what I understand is, if you use this CC license, you can't revoke this. You can't tell me, oh no, sorry, this is going to be not. I will remove this license from. I will remove this CC license from the public. That's impossible, because the terms and conditions in it include that this thing is going to be used for everyone. Can be used for everyone. It has been licensed out to everyone, and anyone that has this license, this document, all the paper, of course, evidence and everything, that this is licensed out by the original creative work artist or author. You can't revoke it anymore. If that person continues to use it for commercial purposes, you can't do it. Hey, you're committing copyright infringement. No, you can't do that at all. So yeah, I would actually caution anyone, thinking this might be the easy way to put out a art commission terms and conditions for people to use your work. No, this is not. This is not, all right. This is not a shortcut way to make your terms and conditions. If you're a art commissioner or someone that is being hired to do some sort of a creative work, whether it's a movie, whether it's a song, anything really that is can be copyrighted, and you are doing this on a client-to-client basis, your terms and conditions with the clients should always be a private one, right? Not based on the terms and conditions found in this CC licenses, right? All right. In any case, we'll go into all one of it at least. All right, one of it, right? This, which is called CC BY. This license allows reusers to distribute, remix, adapt, and build upon the material in any medium or format, so long as attribution is given to the creator. The license allows for commercial use. CC BY includes the following elements: BY, this dude, logo here. Credit must be given to the creator. So from just looking at this, it seems that you can use whatever work has been marked as CC BY, and the only thing you have to do is credit the creator, and you can use it. But we'll look into what exactly the terms and conditions inside this license is, right? There's most likely going to be more stuff that they're talking about, right? So they from the page of talking about the different licenses, they also have this page, which is still a summary of the license. This is not actually the terms and conditions of the license. The terms and conditions of the license is in here, right? In here, right? So again, but for everyone's sake, I'll just read through all this as well. You are free to share, copy, and redistribute the material in any medium or format. Adapt, remix, transform, and build upon the material for any purpose, even commercially. The licensor cannot revoke these freedoms as long as you follow these license terms. Yeah. Again, if any licensor, if any person wanting to use CC license, this can't be revoked. This thing can't be revoked. Okay? Under the following terms: attribution. You must give appropriate credit, provide a link to the license, and indicate if changes were made. You may do so in any reasonable manner. but not in any way that suggests the licensor endorses you or your use. Excuse me. No additional restrictions. You may not apply legal terms or technological measures that legally restrict others from doing anything the license permits. So yeah, one thing to note is, yes, this is a license template for you to use for open licenses, but you can't edit this, right? You can't add terms into it. If you add terms into it, then I would say, what's the legal repercussions? It would be that, it would not be recognized as a CC license. In probably a lot of legal jurisdictions, if you'd edited it. This is what I can say on surface, right? Because supposedly the CC licenses are supposedly enforceable in the entire world. So any country that breaches or has broken some sort of license terms and conditions, any court in the world will be able to enforce this and enforce the breach, right? So if you add terms into it, it might not be recognized at all. It might turn into something more or less a personal license, right? A private license instead of like an open license. Well, the opposite, I guess, would be called closed license, but I don't think that's a thing. Don't quote me on that though. But yeah, if you did amend terms and conditions over there, right? Like adding restrictions or something, then yeah, it won't be considered a CC license anymore, and you have to draft your own license, because supposedly, as long as you tell people that this creative work that you have is marked with the CC BY 4.0 mark, then there's no need to look into any document that you personally provide to anyone that is using your creative work. Everyone that uses your creative work that is marked by CCBY would just have to go through their website here, right? They just have to go through their website here and look at the license terms and conditions, and there's nothing else. Right. Notices. You do not have to comply with the license for elements of the material in the public domain or where your use is permitted by an applicable exception or limitation. Right. These are like exceptional, like in general. No warranties are given. The license may not give you all of the permissions necessary for your intended use. For example, other rights such as publicity, privacy, or moral rights may limit how you use the material. Yeah, so I mean, of course, right? You can't, even though you're allowed to use however you want it to, however you want with the creative work, doing things that are illegal, criminal, or are not allowed for whatever reason, because of rules or policies of some place or website, whatever, is still something you have to look into. Right. So that's the summary of it. So what we have to look into, what exactly are the terms and conditions in it. Right. So these are the terms and conditions in it, and it's a bit long. It's a bit long, and yeah, they are very thorough. They have several languages that the creative licenses are in as well. So if you don't know English, yeah, there's I guess this is Dutch. Dutch is German language, Germany language. Spanish, Jose, yeah, bahasa Indonesia, even bahasa Indonesia, Italiano, and Japanese, and of course Chinese, all that stuff. All these languages is available. You can't really say, no, I don't know, I don't understand English, so I have no idea what CC license terms and conditions are. Well, providing so many variations help for you to understand the terms and conditions. Right, so we'll be reading the entire thing, of course. We don't want to miss anything and just assume. Right. All right, so we started with here. Creative Commons Corporation. Creative Commons is not a law firm and does not provide legal services or legal advice. Distribution of Creative Commons public licenses does not create a lawyer-client or other relationship. Creative Commons makes its licenses and related information available on an as-is basis. Oh no, did I get disconnected? I can't tell. Nope, I'm not disconnected. Sorry. Let me continue. Distribution of Creative Commons public license does not create a lawyer, client, or other relationship. Creative Commons makes its licenses and related information available on an as-is basis. Creative Commons gives no warranties regarding its licenses, any material license under their terms and conditions, or any related information. Creative Commons claims all liability or damages resulting from their use to the fullest extent possible. So yes, this is something people would have to really take note. All right, I hear you. All right, good. Thank you, Neon. Thank you. Is that, you know, Creative Commons is providing you this terms and conditions, this license, but they don't promise you anything that, you know, they are not responsible. If let's say you had some sort of problems that incurred you cost, loss, damages, or whatever by using this license, all right? Maybe because you accidentally told people, yeah, it's under the CC license, you just have to read that or something, and then you assumed things, right? And you ended up in some sort of trouble, and you think it's Creative Commons problem. No. Creative Commons has already stated all these things to you. You know, this is just something that you can use, all right? It is enforceable, right? But other than that, they don't say, oh yeah, if you use these terms and conditions, you're going to be safe, or you're going to not incur any loss, or will not suffer anything at all. No, that's not what they're promising. They're only promising that all this is going to be enforceable, usable in the entire world. Okay, sorry, I thought I was hearing things. But yeah, again, this is something that not everyone is going to be using, right? And again, Creative Commons is not illegal. Yeah, if it's not obvious, they are not a law firm. They are a non-profit organization. So it's a bunch of people who just, you know, came together and decided, yeah, it's there's this niche in copyright, right, where people want to provide licenses for like the public to use, so that they don't have to like draft their own terms and conditions every time, so, and make sure it is applicable for everyone and for an indefinite time, right? So yeah, they decided, you know, we'll found a organization, and we'll make licenses that is usable for everyone, and it won't change for most of the part, right? Because they have updated it, right? They right now it's 4.0 version of the CC license. So there was 1.0, 2.0, and 3.0. There are still the previous license versions, and I'm just assuming, of course, I didn't check the previous versions, but I'm assuming they are still valid, right? Anyone that is has provided their creative works under the previous versions of the CC licenses are still enforceable, are still valid, right? It doesn't mean that if there's a new version, then yeah, everything has to follow the new version. This is exactly the reason why it's called irrevocable, right? Even if there's a new version, it won't be revoked the previous version that you have previously used or declared it will be under. If you declared your creative works will be under the license. Anyhow, let's move on. So these aren't terms and conditions, they are just disclaimers yet first, and explanations. We haven't even gone inside the terms and conditions. Right, so now they are explaining how you are going to be using this. Using Creative Commons public licenses. Yeah, so either they call it public licenses or open licenses. It's the same thing. Right. Creative Commons public licenses provide a standard set of terms and conditions that creators and other rights holders may use to share original works of authorship and other material subject to copyright and certain other rights specified in the public license below. The following considerations are for informational purposes only, are not exhaustive, and do not form part of our licenses. Yes, so as I said, this is not a actual terms and conditions, it is just an explanatory note for people that wants to use it, right? So they both have explanation for licenses, they also have explanation for the public, right? So both parties would understand how to read through all this stuff and whether to use it or not. Right, so first, for licenses. Our public licenses are intended for use by those authorized to give the public permission to use materials in ways otherwise restricted by copyright and certain other rights. Our licenses are irrevocable. Licensors should read and understand the terms and conditions of the license they choose before applying it. Licensors should also secure all rights necessary before applying our licenses so that the public can reuse the material as expected. Right? Licenses should clearly mark any material not subject to the license. This includes other CC licensed material or material used under any exception or limitation to copyright. Right. So what this means, right, is again, once you apply this, once you tell people in the public that this is going to be the license for your whatever creative work you have marked, it is irrevocable, right? It can't say, no, I take it back. It's impossible to take it back once you use this. Licensors should also secure all rights necessary before applying the public licenses. So this means that you must remain, once you have this license put out, all right, or for people to use, anyone that is using this creative license can't do it for any other purpose that might affect this license. Which, of course, the most simple example I can think of is, transferring your copyrights to another person, and maybe adding something to it, or like adding more restrictions for that person to use for that new copyright holder or whatever. That might affect this license, right? From what, just to tell you, take note is, even if you, let's say, you transfer this license, transfer the copyrights to another person or another company or entity, most likely this license won't be affected. But if you have to at least, protect yourself as the person original copyright holder, to tell people that, this copyright work has a public license attached to it, right? You don't how do you say, transfer or sell your copyrights to another person. Don't tell them about this, and you get in trouble. All right, you get in trouble because that person, if that person doesn't know a CC license is attached to the copyright work, they're going to be doing something might cause them loss or damage or whatever, and they will point their finger at you. Anyhow, so that's that. And of course they tell you to mark it exactly, to specify exactly, clearly mark any material not subject to the license. So either tell people which part of the copyrighted work is under this public license and which part is not, right? You should be very clear about that. So for example, again, we can look back at this. We have a real life example and very recent example where how they mark their copyrighted work in such a way under the license, and pretty much they did it in a very simple way, and I've seen articles, I've seen discussions about it where this could be a problem. This is a huge problem because they are not very specific about which is which, right? So the only thing they did in this document is saying, yep, everything in this document, everything, this 400-page document is under this CC license. So, and they didn't mention anything that isn't under this CC license in this document. So we can safely assume everything in here is part of the CC license. So people have said, again, there's a lot of names, characters, monsters or spells or whatever that is supposed to be D&D's copyright works that they vehemently protect is now under CC license and it's irrevocable. So yeah, someone's gonna get fired at least in the legal department or whatever. Anyhow, back to the thing. Supposedly there are more stuff for you to consider, so why not look into that, right? Yeah, so apparently it's on the Creative Commons wiki page. Okay. Considerations for licenses. Irrevocability. Remember, the license may not be revoked. Once you apply a CC license to your material, anyone who receives it may rely on that license for as long as the material is protected by copyright and similar rights, even if you later stop distributing it. Type of material. Make sure the material is appropriate for CC licensing. CC licenses are appropriate for all types of content you want to share publicly, except software and hardware. Ooh. So apparently that's not included. Software. We recommend against using Creative Commons licenses for software. Instead, we strongly encourage you to use one of the very good software licenses which are already available. We can recommend considering licenses listed as free by the Free Software Foundation and listed as open source by the Open Source Initiative. I very understand. It's understandable. I've heard of the word open source and I've heard of this organization called Free Software Foundation. So basically, yeah, software is something, I guess you can say it's not really covered under copyright laws, at least in the basic sense. So I'm guessing Creative Commons license don't want to include terms and conditions that is involving software, because they will make it messier, maybe. So yeah. And there's already another organization that is specialized in software copyright. So yeah. Let me go back over here. Specify precisely what it is you're licensing. Any given work has multiple elements: text, image, music. Make sure to clearly mark or indicate in a notice which of those are covered by the license. Nature and adequacy of rights. Make sure the material is subject to copyright or similar rights. CC licenses are operative only where copyright, sui generis, database rights, or other rights closely related to copyright come into play. It should not be applied to material in the public domain. Yeah. So there's a lot. There's a lot of considerations. Clear rights needed to use the material. If the material includes the rights held by others, make sure to get permission to sub-license those rights under the CC license. If you created material in the scope of your employment or as a work for hire, you may not be the holder of rights and may need to get permission before applying a CC license. Yes, this is complicated for a number of reasons. Copyright holders, determining who is the copyright holder is a complicated issue, which has come out in a lot of cases. I've researched on this, and A lot of times it's because there is a difference between the original author, the publisher, the producer, or whatever you want to call them. There's so many different entities involved. If let's say the creative work is a movie, right? If it is a movie, it's very complicated. It's because a movie involves so many different creative works, right? In it, not only is it there's the editing process, there's the art process, there's this maybe special effects process, there's also the voice acting, maybe there's the actors, actresses providing some sort of a creativity. There are probably props as well. All these things are considered creative works and has to be spelled out very clearly, and who owns all of this, or partially, or in any way they want to word it. And if it's if the ownership of the copyright work, the movie, is split into all different things, I haven't even mentioned scripts. That's something else as well. Scripts, it's going to be complicated to determine who is the owner, right? Even with terms and conditions, because copyright ownership works like a tree branch, like a family tree branch, depending how you word it. That some people have a higher authority, some people have lesser authority, because yeah, it's complicated. In any case, I don't want to try and further explain this without actually going to actual cases. Suffice to say, yeah, complicated. Indicate rights not covered by the license. Prominently mark or indicate in a notice and any rights held by third parties, such as publicity or trademark rights. This includes any content you use under exceptions or limitations to copyright, and any third-party content used under another license, if it is the same CC license as you applied. Right. So many considerations. Type of license. Think about how you want the material to be used. Consider what you hope to achieve by sharing your work when determining which of the 6 CC licenses to apply. What? Isaac, thank you for the subscription. Welcome. Good afternoon. Hope you slept well. Okay. And thank you again for the sub. It's 10 months. You're 1 month less than Doctor, but pretty close. All right. For example, if you want it to appear in a Wikipedia article, it must be licensed using BYSA or a compatible license. Yeah. I think this is simple. Consider any obligations that may affect what type of license you apply. Think about any obligations you have, such as licensing requirements from a funding source, employment agreement, or limitations on your ability to use a CC license imposed by a collecting society. Dictate which, if any of the 6 licenses you can apply. Oh yeah, so complicated. If it involves so many different parties, it's yeah. You have to consider a lot of things. Creative Commons for what exactly? Arion. Arion, I would say, please do not make too much, use too much of the sound alerts right now. We're doing a live seminar, and I want to do this quick, so smoothly as possible. If you don't mind, apologies. But yeah, Isaac, Creative Commons for what exactly? Simply put, it's for people that want to provide their creative work for the public, right? They don't want. The thing is, there's a difference between public domain and having your stuff put in Creative Commons license, right? Public domain is, if you say your work is going to be put in public domain, it means there's no restriction at all. For example, Sherlock Holmes, I think, recently went into public domain, right? Oh no, Ariel, it's fine. If you want to stay, you can stay. Uh, if let's say yeah, Sherlock Holmes became public domain. So basically, anything that is I'm not that certain. Anything that is created by the original author of the Sherlock Holmes, or at least the character Sherlock Holmes, can be used in any way possible without even the need to credit anyone, the original author or whoever that is part of the Sherlock Holmes story. So yeah, that's public domain. But Creative Commons license, there is still some restrictions, which we'll get into. Let's see what exactly are the restrictions, at least for the one type of license that we're going to look through, right? There is still going to be some sort of restrictions when you use Creative Commons license, right? Why would someone use Creative Commons license if, let's say, they totally want people to just freely use it? There are reasons. For one, right, is the current license that we are talking about, CC BY 4.0, essentially is for people that just want to be credited for their work, for whatever reason you're using it for, right? They just want people to recognize who the original author is. So I guess this is, pretty understandable. They don't want to profit out of their work, but at least to be acknowledged, recognized, and credited as the original author, the person that is responsible for providing such a work in the first place, right? There are other restrictions as well, stricter restrictions. Stricter licenses. Yeah, a total of 6, and essentially they are like all the differences between them is, one is the least strict, and the final one is going to be the most strictest. Anyway, I hope you have a great stream and fun, and also serious stream. When it comes to YouTube videos, I'll stop the redeem sounds only because I don't want to interrupt you and play. No problem. It's okay. You don't have to explain to me. As long as you understand it, it's fine. All right. Thank you, Arion. Thank you for understanding. But yeah, that's pretty much what I can explain. So right now we're looking into what Creative Commons, the organization, is telling you what to consider, right? So there's a lot of things to consider, because this is not a simple matter, right, for people to just willy-nilly apply this. But apparently, again, Wizards of the Coast seemed like they just applied this willy-nilly without much consideration. Right. Additional provisions. Consider offering a warranty. If you are confident you have cleared all rights in the material, you may choose to warrant that the work does not violate the rights of any third parties. Oh, yeah, I guess you can add this sort of things. Specify additional permissions if desired. You have the option of granting permissions above and beyond what the license allows. For example, allowing licensees to translate ND licensed material. If so, consider using CC Plus to indicate the additional permissions offered. Oh, okay. So you can't add more restrictions on your own, but you can add more permissions, but using their tool, which I guess it's called CC Plus. Right, see you on the next scene. All right, Arion. Bye-bye. Hope to see you again. So yeah, apparently you can add permissions. You can add more things that people can do with your work, although I guess not necessary. Again, we have to look into the terms and conditions to see why were they this way before I made too much of an assumption. And we have special preferences. Specify attribution information if desired. You may indicate particular attribution parties, a URI for the material, and other attribution information for licensees to retain. Yep. So basically, yeah, if your license requires people to credit you, then you have to specify how they should be crediting you. I guess this is, fair and reasonable to add in. indicate any non-binding requests. You may ask licensees to adhere to your special requests, such as marking or describing changes they make to your material. Yep. Non-binding requests. Okay, I guess you can add those things, but it's not legally binding. Right, so that's the considerations for licensors. We're not even going into the terms and conditions yet. We're just moving on to the public. And then we're going to see what Creative Commons is telling the public how to use these licenses. All right. By using one of our public licenses, a licensor grants the public permission to use the licensed material under specified terms and conditions. If the licensor's permission is not necessary for any reason, for example, because of any applicable exception or limitation to copyright, then that use is not regulated by this license. Our licenses grant only permissions under the copyright and certain other rights that a licensor has authority to grant. Use of the licensed material may still be restricted for other reasons, including because others have copyright or other rights in the material. A licensor may make special requests, such as asking that all changes be marked or described. Although not required by our licenses, you are encouraged to respect those requests where reasonable. More considerations for public. We'll go into that further, but I think this are all very self-explanatory. I guess except for this one. Licenses permission is not necessary for any reason. This is going to be hard for the public to find out, I would say. Is that even if, let's say, they are trying to tell people, even if the licensor tells people that they are using the CC license, the public have to find out whether this license is applicable in the first place. So understandable, actually, quite reasonable and fair to tell people this, and to tell people of the risks. Actually, this is telling the public about the risks of using CC license declared by a licensor, but by someone, right? If that person doesn't actually have the right to tell people that, yeah, this thing is under CC license, then you're in trouble if you try to rely on this. Rather than it will be in the licensor's trouble. Yeah. So what I mean is, essentially, it might turn out, you can't use it in the first place. Right. Our license grant only permissions under the copyright and certain other rights that a license has authority to grant. Yeah. Again, this is something I didn't think about. Is that licenses could be not applicable to use this license, to use the CC licenses. Use of the licensed materials is still restricted for other reasons, including because others have copyright or other rights in the material, blah blah. Yeah, the entire thing is talking about that. Is that, yep, you're telling you might not be able to use this CC license. Or we can put back the analogy to the Wizard of the Coast statement on this, whether or not they have the right to mention this. I would say there shouldn't be any trouble, unless you're telling me D&D Beyond is not part of Wizard of the Coast. Yeah, it's part of Wizard of the Coast. Dungeons & Dragons, D&D, and their respective logos and all Wizard titles and characters are property of Wizard of the Coast LLC in the USA and other countries. So yeah, I would assume they have the rights, since it's the parent company telling all this. It's not just D&D Beyond. You would say executive producer Dungeons & Dragons. Oh, thank you for the raid, Ambi. Thank you for the shout out, AZ. Welcome, Ambi. We're going through Creative Commons right now. Apologies if I am not able to, do all the usual things. We're trying to get through all this stuff as quickly as possible because we haven't even touched on the terms and conditions in the Creative Commons licenses. But if you have any questions regarding this topic, feel free to ask. All right. Hello Hinge. Hello MB. You are playing Legend of Zelda. Nice. Wind Waker. How far are you in the game? It seems like you've been playing that game for forever. But yeah, so let me look at the additional considerations for licensees. Understand the license. Read the legal code, not just the deed. The human-readable deed is a summary of, but not a replacement for the legal code. It does not explain everything you need to know before using the licensed material. I'm so sleepy, can't think. I'm almost sound, I think. Oh, Ambi. If you have to go and sleep, please do so. It's already nice for you to drop by and raid me. You know. Hope you have a good rest. All right, and see you tomorrow. Maybe. I'll be busy tomorrow. Unfortunately, maybe at night. At night you probably would be sleeping. Anyhow, I'll see you when I see you. Anyhow, yes, back to this one. Make sure the license grants permission for what you want to do. There are 6 different CC licenses. 2 of the licenses prohibit the sharing of adaptations, 3 prohibit commercial use, and 2 require adaptations be licensed under the same license. Oops. Take note of the particular version of license. The current version, 4.0, differs from the prior versions in important respects. Similarly, the jurisdiction ports may differ in certain terms, such as dispute resolution and choice of law. Yeah, so people will have to take note about the different versions of the licenses. Hope your stream is going well and have a great rest of your day. Yes, it's doing really well so far, I think. I'm able to quickly go through all this stuff. But yeah, good night. Good night, Ambi. Scope of the license. Pay attention to what exactly is being licensed. Licensors should have marked which elements of the work are subject to the license and which are not. For those elements that are not subject to the license, you may need separate permission. Consider clearing rights if you are concerned. The license does not contain a warranty, so if you think there may be a third-party rights in the material, you may want to clear those rights in advance. Some use of the licensed material do not require permission under the license. If the use we want to make of a work falls within an exception or limitation to copyright of similar rights, you may do so. Those uses are unregulated by the license. Sorry. Yeah, they are saying, you know, maybe there are exceptional limitation. Maybe there are parts of it is gonna public domain. We'll look into it, what this means. Can you just jump me to that place? No. Exceptions. Do I have to comply with license terms? If not, what are the exceptions? You need to comply with the license terms if what you are doing would otherwise require permission from the rights holder. If your use would not require permission from the rights holder because it falls under an exceptional limitation such as fair use, or because the material has come into the public domain, the license does not apply, and do not need to comply with its terms and conditions. Additionally, if you are using an excerpt small enough to be uncopyrightable, the license does not apply to your use, and you do not need to comply with its terms. However, if you are using excerpts of CC licensed material, which individually are minimal and do not require license compliance, but together make a significant copyrightable chunk, you must comply with the license terms. For example, if you quote many individual lines from a poem across several sections of a blog post, and your use is not a fair use, you must comply with the license even though an individual would have been a substantial enough portion of the work to require this. Right, so what this tells me is that what the exceptions they refer to that a CC license will not apply is when, you know, either it's public domain or it falls under fair use. Well, public domain I understand, but saying if it's under fair use, then you don't need to use the license is risky. And they are not lawyers, so you shouldn't really adhere adhere what they are saying. Because again, pretty sure people who attend my live seminars by now, I have heard of this, is fair use is not a right, okay? It's a defense against copyright infringement, right? So basically, if you don't use the license, you're committing copyright infringement, and then you have to prove that your use is considered fair use. And that is not something you want to try your luck with. Anyhow, know your obligations. Provide attribution. All CC licenses require you to provide attribution and mark the material where you share it publicly. The specific requirements vary slightly across versions. Do not restrict others from exercising rights under the license. All CC licenses prohibit you from applying effective technology measures or imposing legal terms that would prevent others from doing what the license permits. Restrict others from exercising rights under license. Yeah, I guess. Determine what, if anything, you can do with adaptations you make. Depending on what type of license is applied, you are limited in whether you can share your adaptation. If so, what license you can apply to your contributions? Yep. All this is more or less the considerations by the public to use this license is telling them read the terms and conditions. That's pretty much it. The first thing, all this stuff, you just have to read the first part, understand the license, and all this is just clarifications, explanations of what that means. Determine what, if anything, you can do. Yeah, I've done it. Termination is automatic. All CC licenses terminate automatically when you fail to comply with its terms. If the material is under a 4.0 license, you must fix the problem within 30 days of discovery if you want your rights automatically reinstated. This is most likely this is part of the terms and conditions. We can learn all of it in one document. Consider licensor preferences. Consider complying with non-binding requests by the licensor. The licensor may make special requests when you use the material. We recommend you do so when reasonable, but it is your option and not your obligation. I don't know why they have to put this though. I mean, yes, you can request people to do something, but since it's not legally binding, you can just omit this out as a suggestion, really. Like it's like what it sounds like to me is in a contract, right? You put all the terms and conditions, and one part of it is like there's a condition telling the person you may consider buying me lunch if you want to, something like that. If someone puts a terms like that, it's basically non-binding. It just says you can if you want to, but it's not an obligation. It's not legally binding or anything if you don't do it. So yeah, there might be reasons for it, but I can't see it. Even as a legal practitioner, I can't see why you have to put that in. Anyhow, I think we're done with all the considerations. They're very thorough, to say the least. All right, they're very thorough in trying to explain things to you in a casual but still formal and serious way, right? Still understandable for most people. But we'll have to look through all this stuff as well, the actual terms and conditions. Give him a moment. I'll have to hydrate. Oh man. All right. I guess before I start, maybe I'll just look at this. I don't think there will be questions. All right. Yeah. There's no question, so I am good. All right, let's go and see the terms and conditions. Creative Commons Attribution 4.0 International Public License. By exercising the license rights defined below, you accept and agree to be bound by the terms and conditions of this Creative Commons Attribution 4.0 International Public License. In brackets, public license. To the extent this... Oh, well, you managed to... Wait. Yeah, because I think the stream just restarted itself. So I guess you're able to redeem first. But welcome. Welcome. So if you have any questions about Creative Commons, feel free to ask them, alright? I can repeat them if you want to. Even if I've covered them earlier. Alright, to the extent of this public license may be interpreted as a contract, you are granted the license rights in consideration of your acceptance of these terms and conditions, and the licensor grants you rights in consideration of the benefits the licensor receives from making the license material available under these terms and conditions. That's a lot of words, just to tell you what this document is about. They're telling you this license is a contract. All right, it's a contract. Simple. You are granted license rights in consideration of acceptance of these terms. Yeah, so this is a contract, and this contract is about you being able to use whatever it is marked with this license. Of course, you have to comply with terms and conditions in the license. And yeah, then only then they will grant you the rights to use whatever they call it licensed material, which they didn't mention. But is it mentioned over here? I don't think so. So I guess you don't exactly have to mention in the exact words what licensed material is. As long as you just make a sweeping statement saying everything in this document is considered can be used licensed out under this CC-BY 4.0. Right. Then we start with section 1, definitions. The adapted material means material subject to copyright and similar rights that is derived from or based upon the licensed material, and in which the licensed material is translated, altered, arranged, transformed, or otherwise modified in a manner requiring permission under the copyright and similar rights held by the licensor. Copyright and similar rights is found under there. All right, we'll go through that one. Okay. Apparently, there's links. Oh no, it's just links to the same page. All right, it's fine. CC-BY. Are you talking about a different license or something? Because I don't think there's a CC-BY. There's a CC-BY, CC-BY-NC, CC-BY-NC-SA, CC-BY-ND. And there's CC-BY-NC-ND. Oh, I thought you should say that. No. It's fine. Yeah, I said CC-BY. There's a lot. No, there's 6 licenses. It's actually really easy to understand. There's 6 Creative Commons licenses, but the difference between them is that there's the least restrictive and the most restrictive license. Really, it's that simple. Depending on if it's more stricter, because then if it's stricter, there will be more terms and conditions telling you how you only can use this, copyrighted work under this license. Right. So adapted material, essentially, this section 1 definitions. All right. From my experience, this entire section is just telling you all the terms and all the definitions of the words, all right, of the words they may be using under these terms and conditions, right? So adapted material is basically what you can do with the copyrighted work. So they mention all sorts of things like translated, altered, arranged, transformed, or otherwise modified in a manner requiring permission under this copyright and similar rights. So adapted material is all the things that listed under this one. So we'll read this first and then only read this, all right? A copyright and similar rights means copyright and or similar rights closely related to copyright, concluding without limitation performance, broadcast, sound recording, and sui generis database rights, without regard to how the rights are labeled or categorized. For purposes of this public license, the rights specified in section 2B, 2B1 to 2 are not copyright and similar rights. Oh, okay. Very general. Now we'll look at this. Adapter's license means the license you apply to your copyright and similar rights in your contributions to adapted material in accordance with the terms and conditions of this public license. Yeah. Adapter. You may apply let's look at what you means. You means the individual or entity exercising the license rights under this public license. Your has a corresponding meaning. All right. So when it says you, it means the person that is using this license, not the licensor. Yeah. Okay. Sorry, man. Basically, this means adapter's license just means you are using this license. What is license for you to use? It's very confusing, but it's basically telling you what you can do with the copyrighted work, and that's the adapter's license. And we have effective technological measures, means those measures that in the absence of proper authority may not be circumvented under laws fulfilling obligations under Article 11 of the WIPO Copyright Treaty adopted on December 20th, 1996 and all similar international agreements. And I think these are very technical things. Need to really understand them. Exceptions and limitations mean fair use, fair dealing, and or any other exception or limitation to copyright and similar rights that applies to your use of the licensed material. Right. Licensed material, license rights. I think I will skip this, but let me see. I keep seeing this. I have no idea what this is. Sui generis database rights means rights other than copyright resulting from Directive 96. Oh, this is European stuff. European Parliament and on the legal protection of databases as amended and or succeeded, as well as other essentially equivalent rights anywhere in the world. Legal protection of databases. So I guess this is some sort of like privacy law that is applicable for Europe, in the European Union, most likely. Right. So let's move on to section 2. I think this is the main course, the terms and condition. License grant. Subject to the terms and conditions of this public license, the licensor hereby grants you a worldwide, royalty-free, non-sublicensable, non-exclusive, irrevocable license to exercise the license rights in the licensed material, reproduce and share the licensed material, in whole or in part, and produce, reproduce, and share adapted material. Yeah, so the first sentence here, we have to I'll try to explain this word by word, all right? It's basically telling you have the right to use this worldwide. Worldwide basically means use it anywhere, right? You can use it anywhere, and it's royalty free, meaning you don't have to pay anything to the licensor. Non-sub-licensable, meaning you can't, when you're using this license, you can't sub-license it. You can't transfer this license to another person, right? Non-exclusive, right? Meaning to say this is well, not exclusive. It's not individual. It's not personal. Okay? It's not uniquely yours. It's standard, kind of like this. That's kind of what it means. An irrevocable license. So meaning to say can't be revoked. Can't be cancelled, can't be terminated, can't be withdrawn to exercise the license rights and license material. So to do what? To reproduce, to share license material in whole or in part, to produce, reproduce, and share adapted material. Right, so there's licensed material and adapted material. What is licensed material? Licensed material means artistic or literary work, database, or other material to which the licensor applied this public license, right? And what is adapted license? Adapted material. Okay, it's basically things that have been modified, but by who exactly? Okay, I kind of understand. Basically, imagine, so again, we go back to the sample of this one, Dungeons and Dragons, right? Let's assume Dungeons and Dragons is the material, the license material, right? Dungeons and Dragons is the license material, and whatever is being created under this license material is considered adapted material. Right? Adapted material. So Dungeons and Dragons books, it's a material. Dungeons and Dragons rules, characters, NPCs, it's an adapted material. Everything under the umbrella of Dungeons and Dragons. And however it is made. Maybe there's songs, maybe there are movies, maybe all that stuff. But yeah, going back to this one, you can just limit this to all these things mentioned in the 400 page of details. Man, 400 page of D&D stuff. That's a lot. Right. And we have section 2, sub A, sub 2. Exceptions and limitations. For the avoidance of doubt, where exceptions and limitations apply to your use, this public license does not apply, and you do not need to comply with its terms and conditions. Yeah. So again, this was explained in a different page where it could mean it is this, whatever the thing is maybe under public domain, or you can use it under fair use. And we have sub 3, term. The term of this public license is specified in section 6A. This public license applies for the term of the copyright and similar rights license here. However, if you fail to comply with this public license, then your rights under this public license terminate automatically. So meaning to say, as long as you're using this in accordance to the license, using whatever copyrighted work is in this license, it only terminates, or only stops, gets terminated automatically you can't use this license, meaning if you fail to comply, so there's no time limit. Essentially, there's no time limit. Yeah. So for people who don't really read a lot of contracts, when in this context, right, term means time period. You media and then subform media and formats. Technical modifications allowed. The licensor authorizes you to exercise the license rights in all media and formats, whether now known or hereafter created, and to make technical modifications necessary to do so. Yeah. So they are telling you further what you can use them for, in what format as well. The licensor waives and or agrees not to assert any right or authority to forbid you from making technical modifications necessary to exercise the license rights, including technical modifications necessary to circumvent effective technological measures. For the purposes of this public license, simply making modifications authorized by this section 2 sub A sub 4 never produces adapted material. Understandable. However you use this license, it won't create a new copyrighted work in a sense that is outside of the license, outside of the scope of the license that we cover. Downstream recipients offer from licensor license material. Every recipient of the licensed material automatically receives an offer from the licensor to exercise the license rights under the terms and conditions of this public license. Yeah, so yep. That's meaning to say, as long as the copyright work is under this license, anyone who decides to use this means that the licensor offers the license to them to use exercise the license right. Yeah, offers a license for people to use the copyright work. I gotta say, these terms and conditions are rather technical. They are very professional, and I can tell you this is normal people would not be able to understand what these terms and conditions are referring to or trying to say if you don't exactly read a lot of contracts. I'm having a bit of a difficult time trying to explain this in layman terms because of how they use the words. These are words commonly seen in contracts, all right, but it's not commonly seen in a everyday language. I don't read much. That's dangerous. But yeah, if anything, if people want to read this document, I recommend having someone that is expert, has experience or something to explain this to you, rather than reading on your own. Because if you read it on your own, you have no idea what all this means. No downstream restrictions. All right, you may not offer or impose any additional or different terms or conditions on or apply any effective technological measures to the licensed material if doing so restricts exercise of the license rights by any recipient of the licensed material. Yeah, a lot of words, but essentially they are saying if you use this license, don't incur additional restrictions on someone else. Which is pretty weird. You may not offer or impose any additional or different terms or conditions on or apply any effective technology measures to licensed material. I don't know how you can do that, but I guess when you're like reusing it, redistributing it, they are telling you don't put in additional restrictions. But they don't exactly mention who are you putting these restrictions against. Except they mention license rights by any recipient of the licensed material. So this is confusing, but yeah, it's what exactly I would interpret it is as, if you're using this license, you can't tell other people that you can't use this for whatever, maybe because you have a relationship with the other people that is using this license work, this copyrighted work, maybe. If not, then it wouldn't make sense. Anyhow, Sub 6, no endorsement. Nothing in this public license constitutes or may be construed as permission to assert or imply that you are, or that your use of the licensed material is connected with or sponsored, endorsed, or granted official status by the licensor or other designated to receive attribution as provided in Section 3A, Sub 1, Sub A, Sub I. Basically, this is just telling you, right? Don't tell, when you're using these creative works, don't tell people, you know, the original author, the copyright holder endorsed me, they support me in using this copyrighted work in such a way, and blah blah blah. Whether it's because they whether telling people they've been sponsored, whether be granted official status or whatever that means, endorsed or whatever. So yeah, don't do that. If you break any, again, if you breach any terms and conditions in this one, it is considered terminated unless you rectify it, which they have a term and condition down here. It's not like you can they say, yeah, this particular thing is under the copyrighted under the Creative Commons license, then you can use this for however you like. But license is a license. There are terms and conditions inside it. If you have to comply, that's why they keep mentioning, don't just it's a CC BY and then you just use the material. You have to use the material, you have to use the works according to the terms and conditions, right? Other rights. Moral rights, such as the right of integrity, are not licensed under this public license, nor are publicity, privacy, and or other similar personality rights. However, to the extent possible, the licensor waives and agrees not to assert any such rights held by the licensor to the limited extent necessary to allow you to exercise the license rights, but not otherwise. Moral rights, such as the right of integrity, are not rights. You see, these are the words that make people confused. What is the right of integrity? Right of integrity is the right of an author to ensure that their work is not subjected to derogatory treatment. There's any act in relation to their work that is harmful to the author's honor or reputation. These are considered moral rights. Right, so this is not protected under the public license or anything similar like that. Publicity. So if, let's say, the people are using your work in a way that is not according to your beliefs, your culture, your perspectives, and that's not protected under this license. Interesting. So why this is interesting, because looking back again to the D&D controversy, right? The new OGL, the new open gaming license that they wanted to push out, and was given the reason of that they wanted to stop people from using it, abusing it, right? For whatever, discriminatory reasons or hateful encouraging hateful speech or whatever. But with this license, there's no such protection for the SRD. Okay, so what happened to that goal, Wizard of the Coast? Anyhow, hopefully that is understandable of how I explain it. Patent and trademark rights are not licensed under this public license. Oh yeah, so this is something I want to also try to mention. Is yes, you are allowed to use copyrighted work via this license, but if the copyrighted work also has other rights, intellectual property rights, right, such as patent and trademark rights, you are subjected to those as well. And if under those trademark rights you are unable to use it, then you can't just solely rely on the public license. You can't solely rely on the Creative Commons license to use whatever it is. For example, you can't, if let's say D&D, right, Wizard of the Coast says you can use the word Dungeons and Dragons under this SRD or whatever document. You can't go on and selling stuff and using the word Dungeons and Dragons. Maybe legally you can use it under copyright, but you can't use it in trademark, right? Use it in a way that to operate your business, right? As a brand, as a logo, as a company's representative symbols or whatever you want to call it. That would infringe the trademark infringement, right? You won't infringe copyright infringement. You won't commit copyright infringement, but you commit trademark infringement. So yeah, complicated, but people have to know this, right? The thing is, it can mix together. Creative works and trademarks stuff, things that are registered under trademarks can overlap with each other, right? Like the logo of McDonald's can be considered a creative work, can be copyright protected, but it also can be protected under trademark as well. Anyhow, right, sub 3, to the extent possible, the licensor waives any right to collect royalties from you for the exercise of the license rights, whether directly or through a collecting society, under any voluntary or waivable statutory or compulsory licensing scheme. In all other cases, the licensor expressly reserves any right to collect such royalties. Yeah, I guess they are explicitly telling you again that there won't be royalties to be paid to the licensor. All right. In all other cases, the licensor expressly reserves any right to collect such royalty, meaning to say, in any other situation, maybe involving trademark, I don't know exactly, or thing that is not covered by the license, then yeah, they can still collect royalties. But I don't know why you have to say that. Or I would say, no. I think there's a reason why they put it here. In all other cases, one situation I guess I can think of is if you breach the Creative Commons license, then yeah, they are allowed to collect royalties in such a situation then. License conditions. Your exercise of the license rights is expressly made subject to the following conditions. Attribution. If you share the licensed material, including in modified form, you must retain the following if it is supplied by the licensor with the licensed material: identification of the creators of the licensed material and any other designated to receive attribution in any reasonable manner requested by the licensor, including by the pseudonym if designated, a copyright notice, a notice that refers to this public license, a notice that refers to this disclaimer of warranties, URI of or hyperlink to the, I think this is URL, right? URL? No, I don't know. Or hyperlink to the licensed material to the extent reasonably practicable. Indicate if you modify the licensed material and retain any indication of any previous modification. Indicate the licensed material is licensed under this public license and include the text of or the URI or hyperlink to this public license. Yep. So basically, this entire thing here, since we're looking at CC BY, is talking about how you should be complying with the attribution condition. So you have to do all this, put up a notice, put up the sharing the hyperlink to this license, yada yada da da da. Yeah, so it's not as simple. So again, don't just read the summary of things. Don't just assume, give credit to the copyright holder just means do it however you like. You have to do it in this very specific ways that the license is telling you to do it, right? Don't do one, it's considered breach of contract, breach of the license, and you won't be able to say that you can use this license. Breach of the terms and conditions in here is straight up, it means termination of the license. You may satisfy the conditions in section 3, sub 8, sub 1 in any reasonable manner based on the medium, means, and context in which you share the licensed material. For example, it may be reasonable to satisfy the conditions by providing a URL or hyperlink to a resource that includes the required information in any reasonable manner. Yeah, so as long as you are able to do all this stuff and show it to people in a reasonable manner, depending on what it is. So since again our example is a PDF, right? It's suffice to say you just have to put it up in your website, like here in D&D Beyond, telling people this notice is provided here, the link is here. Even the document itself also provides links. Yep, they're following the terms and conditions to the T. If requested by the licensor, you must remove... Oh, sorry. I don't think that applies there. This should apply to the licensee. So, well, this is more or less the requirements for the licensor. Apologies. Anyways, let's move on. If requested by the licensor, you must remove any of the information required by Section 3, Sub A, Sub 1, Sub A to the extent reasonably practicable. Oof, boy. There's renovation work going on. Oh no. That's not good. Ah man, okay. We don't have a lot yet. Don't have much, so we'll just quickly go through this. Section 4, sui generis database rights. So this is the thing that is applicable for the European Union only, where the license rights include sui generis database rights that apply to your use of the licensed material. For the avoidance of doubt, Section 2, Sub A, Sub 1 grants you the right to extract, reuse, reproduce, and share all or a substantial portion of the contents of the database. If you include all or a substantial portion of the database contents in a database in which you have sui generis database rights, then the database in which you have sui generis database rights, but its individual content is adapted material, and you must comply with the conditions in Section 3, Sub A if you share all or a substantial portion of the contents of the database. This is something that we have to look into ourselves. I would say anyone that is from Europe or part of the European Union will have to learn what this is. Oh, sorry, not this one. They have to learn what this is. The Directive 96/9/EC. Right? Let me just. Is it easily searchable? Yeah, there's a wiki page of it. Directive for the European Union in the field of copyright law, made under the internal market provisions of the Treaty of Rome. It harmonizes treatment of databases under the copyright law and the sui generis right for the creators of database which do not qualify for copyright. So, what is sui generis? It's Latin. Latin phrase that means of its their own kind. The class by itself, therefore unique. Law, when a special and unique interpretation of a case or authority is necessary. Intellectual property rights for types of works not falling under a general copyright law but protected through separate statutes. Okay. Generally speaking, protection for intellectual property extends to intellectual creations in order to incentivize innovation and depends upon the nature of the work and its characteristics. The main types of intellectual property law are copyright, which protects creative works, patent, which protects invention, trademark, However, sui generis statutes exist in many countries that extend intellectual property protection to matter that does not meet characteristic definitions. Integrated circuit layouts, ship hull designs, fashion designs in France. Databases or plant varieties require sui generis statutes because of their unique characteristics. Oh, all right. Now I understand it to a certain extent. Sui generis is basically a law. So at least in our context, is a directive by the European Union, all right, made by the European Parliament and Council. They are a law covering things that are not considered to be copyright works, or works that can't be copyrighted. But with this specific laws, with this specific directive, it allows certain things to be considered protected, to become protected under copyright law. So for this directive, they are referring to creators of databases. So what is database? Yeah, we're learning things. But very niche though. This is for people from Europe only. Article 1 sub 2 defines a database as a collection of independent works, data, or other material arranged in a systematic or methodical way and individually accessible by electronic or other means. Non-electronic databases are also covered. Any computer program used to create a database is not included. Copyright protection of software is governed by Well, this is I have no idea what this is. What is a collection of independent works, data, or other materials arranged in a systematic or methodological way and individually accessible by electronic? Is it some sort of portfolio, photo gallery, cloud system, cloud-based system, cloud server? I think that's what this is. They are protected by copyright as collections. No criterion may be used by the member. Weird. Okay, this is very, very strange. I can see why this is not protected under copyright, because they're saying a collection of something is protected under copyright. This might be why all the VPN and similar systems have their data centers in the EU. Ah, is that so? Yeah, so that's kind of what this means, right? A collection of independent works, data, or other materials arranged in a systematic or methodical way and individually accessible by electronic or other means. But why though? Why should this be protected under copyright? So that someone won't be able to copy this method? Copy this type of collection? The method of collecting data in the works? Well, for whatever reason it is, it seems to seems to be in that area of things. Unless there's a example. I don't think there's a sample. But there are litigations, alright. British Horse Racing Board was the claimant in a notable case. A dispute was the reuse of the contents of their horse racing information subscription service by other parties. Okay. The European Court of Justice ruled in 2004 that the resources used for the creation of materials which makes up the contents of a database are not protected, and BHP nearly lost their litigation. Right. Yeah, because this is 2004. The directive only came into effect. Oh, it came into effect 1996. Yeah, the method of collecting or storing or organizing. Yes. So 96 is already a thing, right? Let's look at another case. Apis Christovich EOOD v versus Lakorda AD, a preliminary court ruling issued in 2009 in response to the Bulgarian court referrals from the Sofiyski Gradsky Sad, Sofia City's court. Apis and Lakorda both operated legal information databases. Lakorda had been set up by former Apis employees, and Apis alleged that Lakorda had extracted data from 2 law information modules within its database. The ruling looked at the meaning of the terms extraction, permanent transfer, and temporary transfer in relation to data, and also established that any module within a database which could be defined as a database under the directive should be treated as a database itself. So, okay. Yeah. This is new to me. Apparently, this is protected under copyright law. I mean, guess the method, right? The method of accumulating something, a data, whether it is information, whether it is actually some sort of creative work, but essentially not just database. Of course, this is a unique creative way of like organizing information, I guess, can be protected under copyright, even though they are not considered copyrightable work. This is fascinating to me, but probably not a lot to people. And let's also look at this case. An ECJ ruling in June 2021 markedly raised the threshold for infringement to occur. A claimant now needs to establish that an alleged substantial extraction also caused significant detriment to its investment in the database. The case itself concerned 2 Latvian companies providing job-seeking services. CV Online Latvia and Melons. Husovec and Derkley opined that the ECJ now requires that all acts of extraction and reutilization must lead to a risk that the database maker is not able to recoup its initial investment because of these actions, and that while considering the risk, the national courts must balance the interests of other parties as part of the infringement test. So this is like a additional factors to consider when what it means when a copyright infringement happens for database, quote unquote copyright infringement. You only have to establish substantial extraction and significant detriment. to its investment in the database. Yeah, alright. Different from, the usual copyright infringement. In any case, my stomach's grumbling for some reason. I'll take a 5-minute break and I'll come back, alright? I'll come back. But suffice to say, this is a good read. A good thing for anyone that is from Europe to understand, hopefully. But what else actually? Is there anything further I need to talk about? Alright, there's not much left, but we'll come back in a short while, alright? BRB. Oh, was being a naughty boy. You're not. I said. Anyhow, I'm back. So we'll be back talking about this. I want to get back to this sui generis database again. So let me see. Where license rights include sui generis database rights that apply to your use of licensed material. For the avoidance of doubt, Section 2 Sub A Sub 1 grants you the right to extract, reuse, reproduce, and share all or substantial portion of the contents of the database. If you include or a substantial portion of the database contents in a database in which you have sui generis database rights, then the database in which you have sui generis database rights but not its individual contents is adapted material. And you must comply with the conditions in Section 3 Sub A if you share all or substantial portions of the contents of the database. For the avoidance of doubt, this Section 4 supplements and does not replace your obligations under this public license where the license rights include or other copyright and similar rights. So this is a bit more complicated if you considering this is not simple matter of individual copyrighted work. But essentially, from what I can tell, this is just them telling you if the licensor is using the public license or providing a public license for database, then this would apply. And this is very strange. It's strange. It might be a very complicated thing. I don't know the intricacies of should be how do you say, worry about or consider in terms of like how to do things, how to do this sort of like extraction or however involves database. Wait, do you call it database or database? Because it could be data or data, but data sounds better, right? Anyhow, let's move on. Section 5, disclaimer of warranties and limitation of liability. Yeah, so this is actually, I would tell you not to ignore everything else, but no, every time there's a contract would say warranties and limitation of liability, but not this one, right? Not this one. Unless otherwise separately undertaken by the licensor. To the extent possible, the licensor offers the licensed material as is and as available, and makes no representations or warranties of any kind concerning the licensed material, whether express, implied, statutory, or other. Right? This includes, without limitation, warranties of title, merchantability, fitness for a particular purpose, non-infringement, absence of latent or other defects, accuracy, or the presence of absence of errors, whether or not known or discoverable. Where disclaimers of warranties are not allowed in full or in part, this disclaimer may not apply to you. To the extent possible, in no event will the licensor may be liable to you on any legal theory, including without limitation, negligence, or otherwise for any direct, special, indirect, incidental, consequential, punitive, exemplary, or other losses, costs, expenses, or damages arising out of this public license or use of the licensed material, even if the licensor has been advised of the possibility of such losses, costs, expenses, or damages. Where limitation of liability is not allowed in full or in part, this limitation may not apply to you. This disclaimer of warranties and limitation of liability provided above shall be interpreted in a manner that, to the extent possible, most closely approximates an absolute disclaimer and waiver of all liability. Right. Again, this is pretty much telling you the licensor is not responsible for anything. Okay? Not liable for anything. They are not promising anything. But they have a sentence over here to say, unless all these disclaimers and warranties are not allowed to be used or in full or in part, then they are not applicable. It's a good thing they put this here, right? So that people understand it depends on what is the context, what is the case happening, what happened, right? What was the liability happening? What was the loss, cost, or result from? Right? Then only we'll have to see whether the licensor is liable, right? So most of the time when you see this disclaimer or warranties, they won't mention that they are not applicable or anything. But over here, they say, yep, they are applicable. They are only applicable if they are allowed, but they don't mention specifically why or when or how to determine this. But it's safe to assume depends on the country, depends on the jurisdiction of your country in regards to suing someone for, as they have put in a example, negligence. But yeah. What I wanted to just, the point is, this is more or less something you have to consider. What is the thing that you're using, and consider the risks, the possible risks. It might be involved in using a certain copyrighted work via this public license. Right, then we have section 6, term and termination. So I already explained this. Basically, as long as you don't breach anything under this license, your license will continue as long as you want, right? As long as you want to use it, it is still going to be applicable. But if there is some sort of breach of terms in the license, then it is automatically terminated. Then if it's terminated and you want it to be reinstated, you have to rectify the breach within 30 days of discovery of the violation. Or, the licensor themselves express reinstatement. They themselves say, yeah, it's fine, you can continue using the license. Yeah, so only those two situations are you able to come back to using the Creative Commons license. For the avoidance of doubt, this section 6b does not affect any right. The licensor may have to seek remedies for your violations of this public license. So yeah, if you violated it and the license gets terminated, any sort of remedies that is naturally coming from like copyright infringement will apply, right? For avoidance of doubt, the licensor may offer the licensed material under separate terms and conditions or stop distributing the licensed material at any time. However, doing so will not terminate this public license. Yeah, so this is this sentence over here is not saying the licensor can cancel the license or anything. They are just telling you licensed material or the copyrighted work can have additional terms and conditions. All right, what exactly are they? Not sure, but in any case they can't go against the license terms and conditions. And of course they can stop providing this licensed material to people. For example, if let's say we're talking about again back to PDFs, books provided by Wizard of the Coast. If they suddenly like say over here, right, the SRD, if they suddenly remove this document from their website, right, it doesn't mean you can't use this material anymore. Even if they don't provide you the SRD officially, if you can get it somewhere else, you can still use it because the license again is irrevocable. Okay. Yeah, right. Section 1, 5, 6, 7, and 8 survive termination of this public license. Yeah, right. Section 7, other terms and conditions. The licensor shall not be bound by any additional or different terms or conditions communicated by you unless expressly agreed. Any arrangements, understandings, or agreements regarding the licensed material not stated herein are separate from and independent of terms and conditions of this public license. Section 8. Interpretation. For the avoidance of doubt, this public license does not and shall not be interpreted to reduce, limit, restrict, or impose conditions on any use of the licensed material that could lawfully be made without permission under this public license. To the extent possible, if any provision of this public license is deemed unenforceable, it shall be automatically reformed to the minimum extent necessary to make it enforceable. If the provision cannot be reformed, it shall be severed from this public license without affecting the enforceability of the remaining terms and conditions. No term or condition of this public license will be waived, and no failure to comply consented to unless expressly agreed to by the licensor. Nothing in this public license constitutes or may be interpreted as a limitation upon or waiver of any privileges and immunities that apply to the licensor or you, including from legal processes of any jurisdiction or authority. Right. So these are pretty standard terms and conditions. I don't think I really have to explain all this stuff. It doesn't really affect. It's not really that important as well. But suffice to say, this is pretty straightforward. Although very professional in the language they use, very straightforward and very thorough. I would say very thorough in what they want to tell people in how to use this license, in what this license provides. Okay. Right, so that's it. What is this? Creative Commons is not a party to its public licenses. Notwithstanding, Creative Commons may elect to apply one of its public licenses to material it publishes. In those instances, will be considered the licensor. The text of the Creative Commons public license is dedicated to the public domain under the CC0 public domain dedication, except for the limited purpose of indicating that material is shared under Creative Commons public license or as otherwise permitted by the Creative Commons policies published at creativecommons.org. Policies. Creative Commons does not authorize the use of the trademark Creative Commons or any other trademark or logo of the Creative Commons without its prior written consent, including with limitation in connection with any unauthorized modification to any of its public licenses or any other arrangements, understandings, or agreements concerning use of the licensed material. For the avoidance of doubt, this paragraph does not form part of the public licenses. Yes, this is not part of the terms and conditions. This is just telling you the license is the Creative Commons takes no part in it. All right, they are just providing the terms and conditions, except when it applies for things that they do own. They do own the copyrights too. But yeah, they're also telling you don't use their trademark as well. Anyhow, I think that's it. And it's so dark. Unless anyone has any kind of questions, I would have to like go and just summarize the things that I have talked about. So at the moment, I'll stop recording. At the moment, I only stop recording until I finish this summary. Then yeah, and we'll move on again. All right, we're back. So I'm going to be summarizing whatever we have learned today on this legal investigations. All right, put it in a FAQ form where I think it will be easier to explain. All right, so Creative Commons. What is Creative Commons? Basically, non-profit organization that publishes public open licenses for copyright holders to use. This is only one of their functions and purposes only. All right, and again, Creative Commons is not a law firm, and it's not a legal advice department or whatever, or legal aid department. They are just a organization that have crafted these licenses for people to use, right? They are not a party of these licenses. They are not going to be the organization to enforce these licenses. The enforcement of these licenses always goes back to the relevant jurisdictions from the countries. All right, all the courts or whatever legal system will be the process for enforcing these licenses as usual. All right. So what are Creative Commons licenses though? They are something that the copyright holders would use. All right, and basically how they use it is telling people what specific creative work is considered to be licensed under this Creative Commons licenses. And basically just by doing that, people will only have to, if they were to use this license, they were to use this license to adapt, modify, distribute, sell, whatever, for whatever commercial purposes for this creative work. They only have to refer to the license provided in the Creative Commons. The terms and conditions are provided in the websites by Creative Commons. They don't have to look anywhere else. All right, if they look anywhere else, that is not considered Creative Commons licenses. That is pretty much established throughout the Creative Commons license, as well as the terms and conditions inside themselves. All right, and they are supposed to be usable by everyone, enforceable by everyone in the world. Of course, there are 6 licenses, 6 types of Creative Commons licenses. Simply put, the only differences is how restrictive they are, right? From least to the most. Other than that, there's not much difference of them. But there's also another type of license called Creative Commons Zero, right? They are not really a license. They are just a tool for copyrighted works to turn them into part of the public domain. All right, and yeah, that's pretty much it. What types are and how are the Creative Commons licenses used? Simply put, very easy, right? Again, the copyright holders will just have to mention this sort of creative works is granted to the public and what type of license is this used under, right? If they mention, like, for example, CC BY 4.0, then that will be the license that everyone has to look into and comply with, right? It's like that. Apparently, why? If you're asking me why is this possible, again, because this non-profit organization, Creative Commons, seems to have like has been established way 2 decades ago, and worked with a lot of departments, government departments, agencies to get all this license recognizable and enforceable throughout the world. So just by having you mention what type of licenses is being used for your creative work is sufficient. You don't have to post the terms and conditions elsewhere. Everything is centralized, which is a good thing, because there won't be any concern of, oh no, the terms and conditions has been changed, I'm complying with a set of different terms and conditions. No, it would say the benefit of using this is reliability, that the licenses won't change. And again, even if they change, right now the version of them is like 4.0, and you use when you apply this license, it was version 3.0. Version 3.0 doesn't mean it's still valid, it's still legally binding, even if it has a new version coming out, because again, all these licenses are irrevocable, right? Irrevocable, meaning to say, no matter what, if there's additional not additional, if there's a new version of the licenses, or even if, let's say, the licensors decided, no, I don't want to give this public license to everyone, they can't do that, right? Irrevocable means irrevocable. Then, of course, for people that is not licensors, the people that want to use creative works via these licenses, will simply use them. But of course, they would still have to understand the terms and conditions of these licenses, all right? But the risks and dangers, right? Again, it's pretty obvious from how I have explained how copyright Creative Commons licenses work. Is, yet again, for copyright holders, the problem is irrevocability, right? Meaning, say, once you decide to put out a creative work, put out a copyrighted work out to the public via these Creative Commons licenses, there's no way of returning, there's no way of going back, there's no changing of your minds, all right? Once you get it out, it's out in the public, right? Regardless of its status, right? It's as if, right? It's as if you put it out in public domain, because in a sense, when you put things up in public domain, it's similarly like forever as well. It won't be except you won't be recognized as the original author or the copyright owner, right? With the licenses, you are still considered the owner. You still have some sort of rights, copyrights over the works, right, for you to enforce. But again, if you don't like how people are using your work, too bad. You can't turn back time. And for anyone that is going to be using the license, or the risk and danger behind it would be, well, anyone can apply this, right? Anyone can use this license. Anyone can say, yep, my work is considered to be what, CC something, CC BY, whatever license they have applied. The problem is finding out whether these licensors, these copyright holders, can do that. Are they legally able to do that? If they can't, right, for various reasons, being the obvious one is they aren't actually the copyright holders, then them giving the licenses out has no use, has no purpose to it, because they don't have the right to give out license in the first place. So if they don't have the right to give out license in the first place, they don't have the right to use the creative works in the first place as well, right? You'll be committing copyright infringement because nobody gave you a license to use whatever it is being used, all right? Simple, right? Then, of course, I already said this, but I should emphasize again, to use the licenses, it's not just simply, yep, I announced this is the license I am going to be using, either by the copyright holders or the people that are using the license to use creative works. All parties have to read through the terms and conditions inside the licenses, which is again provided by the websites of Creative Commons, and don't follow them, then there will be a breach, there will be problems, and you will suffer. All right. But I do have to give additional notice is the terms and conditions is not easy to understand. All right, that part I can't deny, and if you don't understand, don't simply use it. All right, if you don't understand it fully, don't simply use it. Have a lawyer advise you. All right, consult a lawyer, not me. All right, I'm not providing legal advice and all that stuff. Have a lawyer explain to you the terms and conditions and whether it is suitable for you to use them. All right. Anyhow, so then of course we have one thing I would like to mention. Creative Commons licenses might be like a very big thing that covers a lot of stuff, but no, it only covers copyrighted works. All right, and the problem with it might be is even if it covers copyrighted work, there might be stuff that is both copyrightable as well as marketable. How do you say it? So yeah, something could be copyrightable but also protected under trademark as well. So even if, let's say, that creative work is licensed out under the Creative Commons, it's still, there's a possibility you have to comply with trademark requirements or conditions, or you have to get permissions if your use of the work involves some sort of trademark or patent use. All right. And yeah, there's also, of course, the obvious things is don't just simply use licenses for anything, right? Some things are not copyrightable, but there are exceptions which I've listed out there, sui generis. It is mentioned in the terms and conditions for the licenses. But overall, again, we're talking about copyright stuff, so just think of the Creative Commons license as involving copyright stuff only. And of course, all this legal investigations, this seminar happened because of the D&D fiasco. So probably the final question people might ask, right? Or because it's been discussed over and over again because of the developing news on this matter kept changing. There's so many conversations about it has been happening, like the legitimacy of a OGL, the Open Gaming License, what can be actually copyrighted, what is the risks of this new OGL, blah blah. All that conversation has ended, and we ended up with this permanent conclusion, quite permanent conclusion. I would say you can't really talk about OGL anymore, since all this stuff is put inside Creative Commons, and it's irrevocable. The only question is it a good thing? Is it good that all the SRD system, man, what is it called again? System I keep forgetting the name. System reference document. Essentially, everything that is provided in there, all the characters, all the rules, classes, monsters, NPCs, spells, objects, materials, magic items, or whatever you want to call them, that is listed inside the SRD is under Creative Commons license now. It's good for everyone. Why is it good? It's because third parties that utilize the game mechanics of D&D, or even the SRD now, will be free to use them however they like, as long as they comply with the license, which is just to provide attribution for the reserved codes, and they can continue to monetize, commercialize, profit from it, without any concern of a risk by Wizard of the Coast issuing any sort of like a cease and desist or asking for royalties of any kind, right? As long as people comply with the terms and conditions inside the Creative Commons license. So yes, it's good for everyone except for Wizard of the Coast, right? For or I would say originally there wasn't even any problem. There won't be any. There's no loss for Wizard of the Coast if they just remain with the using the OGL. But now they decided to put everything in Creative Commons license. There is no way for them to say, nope, we're going to be changing our mind. We're withdrawing this Creative Commons license, because that's not possible anymore. The only other thing they can do is making a new set of stuff, making a new set of SRD, maybe called SRD 6.0. They probably can reproduce the same content from SRD 5.1, but doesn't revoke it. Again, whether you change it or not, the Creative Commons license is that powerful. Just by having that word irrevocable in it, you can't do anything. You can make it entirely, Wizard of the Coast can make an entirely new system and use entirely different classes or whatever names that are being used in SRD 5.1. But yeah, that will cost them. It will cost them. In any case, thank you so much for watching. I hope you enjoyed this legal investigations. I don't think there's any questions people have asked. So yeah, anyone that is watching this as a VOD, again, thank you. If you have any questions, you may ask them in the comments. And if you like what you see, like the video. And if you want to see more of this content, subscribe for more. Subscribe to the channel for more. Anyhow, take care, stay hopeful, be critical.